So this is like one for one.
Good morning or good afternoon to you.
Good afternoon, colleagues. Thank you so much for joining us this afternoon for our second quarterly media briefing. My name is Pascal, and I'll be directing the program today. Because we are already behind schedule, I will immediately invite the public to address us, or maybe before that, just to mention for the purposes of the that the public protector is flanked by the deputy public protector, Advocate Kwaneka Kalega, who is seated to my far left. And then next to me here is our Chief Operations Officer, Mr. Lucky Halaba. Thank you so much. Over to you, Vicky.
Thank you, Program Director, Mr. Sekhalwe, Deputy Public Protector, Acting Chief Executive Officer, Ms. Lucibane, COO, Mr. Halaba, our Acting Chief of Staff, Ms. Mamabolo, all the executive managers who are here, and thank you so much to the members of the media for making time, ladies and gentlemen, and the public at home. Good afternoon. Thank you once again for joining us for this quarterly media briefing. And this is the second for the 2020 financial year. And we thank you, members of the media, for making time to come, because we wouldn't be able to convey our messages to our target audience. And as often we say, the briefing not only seeks to make or bring the public up to speed with our investigation, but also we are complying to Section 182(5) of the Constitution and Section 8 of the Public Protector Act, which makes it compulsory for us to make our reports public unless mentioned otherwise. So accordingly, I'm releasing 14 investigation reports, which will include irregular appointment of staff, the plight of refugees, whistleblower victimization, abuse of public resources, and the one relating to executive ethics code. Our approach to investigation remains the same. And firstly, we establish what happened, which is a factual inquiry relying on the evidence obtained from the parties and independently sourced during the investigation. Second, we establish what should have happened, focusing on the law and the rules that regulate the standard that should have been met. Thirdly, we establish if there is a discrepancy between what happened and what should have happened, and whether the deviation amounts to maladministration or improper conduct. Once we have established the discrepancy, we then move to the question of remedial action, thereby seeking to explore option of redressing the consequences of improper conduct and maladministration. I will deal with some of these reports and leave others for the Deputy Public Protector, Advocate Kalega, to deal with. Before we deal with the reports, I wish to take this opportunity to make few remarks And as well, the DPP will add to that. We had a webinar which we were encouraging or dealing with how government institutions are using official languages to make sure that there's access to the services of government, but as well, that is one of the pillars of Vision 2023. And we had a very robust debate, and it's a very emotive subject when we were commemorating the Heritage Month. In particular, we looked at the contribution of failure to comply with this legal framework towards service delivery and good governance challenges. Since that is our mandate, always we look what the prescripts are saying and what whether the conduct of government departments is compliant to that. We had a distinct assemblage of panelists drawn from various sectors, academia, arts, and from the National House of Traditional Leaders. So coming out of that conversation, we then agreed that we will conduct a systemic investigation which will deal with how access to other languages and how the SABC, ICASA, and all other relevant institutions, including the courts, are making sure that the usage of indigenous languages is promoted so that people can have access to the services. So I will then move to the other, in fact, we will be working with the Commission for Religious and Linguistics and the PENSAL in our investigations. And further, we have outstanding investigations that have attracted a lot of public interest. One of those relates to the FRIADE investigation into the role of politicians and the plight of beneficiaries in respect of the Estina integrated dairy project. The investigation is all, in fact, it has been completed finally, and the investigation proved to be very complex than we had thought. Thus, various other institutions had to be approached to assist the organization, and this took longer than expected. Only earlier this month, we managed to serve the implicated parties with Section 7(9) of the public notices in terms of the Public Protector Act. We had hoped that once we get the responses, we will then be ready to issue this report today. So some of the parties unfortunately requested extension, and therefore we will have to give them that opportunity, especially in the interest of fairness, so that they can adequately respond to the Section 7(9) notice. And other reports that are in the pipeline include one investigation into alleged maladministration involving the irregular appointment of staff, irregular salary increases, financial mismanagement, procurement irregularities, and conflict of interest within the city of Johannesburg during the time of the former Mayor Herman Mashaba. And the other one relates to the Alexandra Renewal Project, which we collaborated with the South African Human Rights Commission. This investigation followed the violent service delivery protest in the township in April 2019. And on the other matter, we tackling maladministration aspects of the issues in question, including allocation of resources by respective government departments, whilst also dealing with the issue of service delivery related issues. The South African Human Rights Commission is focusing on the human rights related issues. And also in the pipeline is the Mopani Giyani Water Project. This one also is a matter which is being delayed, and also it was delayed by the responses from those implicated, and we should be giving them an opportunity to respond, and instead of just rushing to issue the report without having their side of the story. And we also acknowledge that the communities around Giyani, Mopani district in Limpopo are still facing the challenges. I'll hand over to the DPP to address the COVID-related matters and our visit to public hospitals, and then she will also deal with the various matters which we dealt with relating to the administrative justice and service delivery, which are delegated to her. Over to you, DPP.
Thank you, Public Protector, and good afternoon to you, ma'am. I also wish to extend my warm greetings to the acting CEO, the COO, the executive managers present here, the acting chief of staff, members of the media present, and to the members of the public at home. In a nutshell, we have received 1,602 COVID-related complaints since the lockdown period, the bulk of which relate to service delivery failures. 8 of the total are good governance matters and relate to procurement irregularities with financial implications for the public purse estimated at 4 billion rand. A lion's share of the service delivery related matters in respect of COVID-19 have to do with the 350 rands a month special social relief of distress grant. All these service delivery and good governance investigations are currently in progress. Although we have experienced challenges in some provinces with regard to access the documents and evidence that we had required, this issue has now been settled. As indicated previously, we have established a committee consisting of quite senior and well-experienced investigators whose focus is on these matters. The aim is to dispose of them as expeditiously as possible. We have further embarked on an own initiative investigation into the state of the country's health system, as well as the basic education conditions. The investigation was precipitated by the public outcry and media reports as a result of the current pandemic. As part of this, the Public Protector and I have embarked on visits to hospitals and schools to establish, amongst other things, how they were coping under this current pandemic and how they've been dealing with the COVID-19 related impact and the general state of our healthcare facilities in respect of whether they are able to render services effectively and efficiently to the citizenry of the Republic of South Africa. We have thus far visited facilities in the Eastern Cape, Gauteng, Limpopo, and Mpumalanga. We will in the coming week be visiting KwaZulu-Natal and the Western Cape thereafter. The details thereof will be communicated in due course. We have in the meantime been in consultation with stakeholders, including the Minister of Health and the Minister of Basic Education, the South African Human Rights Commission, the Office of the Health Standards Compliance, and the Ombuds in respect of our findings and observations where hospitals are concerned and the schools in respect of the basic education. Reports for each province are being prepared for the MECs and the Minister, and we will also share these reports with the Minister of Finance and the President. I wish to now proceed with the main business of the day, which is the findings of the 14 investigations. As TP had alluded, I will then deal with the investigations of service delivery related matters. I would like to start with the matter of Maboho versus the Department of Justice and Constitutional Development, which is report number 87 of 2019-2020. Allegations were investigated of failure by the Department of Justice and Constitutional Development to confirm a position of acting chief magistrate and to effect payment of an acting allowance. The investigation was occasioned by a complaint from Mr. S. Maboho in August 2013. In his complaint, Mr. Maboho alleged that as a senior magistrate at the Pretoria North Magistrate's Office, he acted as chief magistrate from 1 July 2007 to 17 August 2010, following the retirement of the chief magistrate. He alleged that he was never paid his acting allowance for this period. However, he was paid an acting allowance from 18 August 2010 to 17 November 2010 after being appointed to act in the position. He also alleged that he raised the matter with both the former Minister and Deputy Minister of the Department of Justice and Constitutional Development, as well as the Director General. When the department failed to respond to his complaint, he decided to turn to the Magistrates Commission and lodged a grievance. Mr. Maboho further alleged that in response to the grievance he had lodged, a former Deputy Minister of the department refused to issue an acting judicial appointment to him as an acting chief magistrate, citing a decision by the former minister that the position of chief magistrate from the Pretoria North Office, which had become vacant after the incumbent of the post retired, was kept in abeyance pending the redemarcation of the magisterial districts. Furthermore, that the post of chief magistrate would be hugely affected by the pending redemarcation process. This is despite the fact that in numerous correspondence the department addressed to him as acting chief magistrate. According to Mr. Maboho, the grievances committee of the Magistrates Commission, however, upheld his grievance on the grounds that the post had not yet been abolished and was still a funded post in the Pretoria North Office, and further that the structure thereof had not changed since the former chief magistrate had retired. Other acting chief magistrates in the area were being paid as the acting allowance, a matter he raised with the department pursuant to the recommendations of the Magistrates Commission. Was all in vain. After analyzing the complaint, it was then decided to investigate whether the department improperly advised the minister and failed to confer any benefit to Mr. Maboho of him having performed duties and mandatory responsibilities in the position of chief magistrate that had become temporarily vacant during the period of 1 July 2007 until 17 August 2010, and whether he was improperly prejudiced by performing duties of a chief magistrate without being remunerated. I found that indeed the department improperly advised the minister and failed to confer any benefit to Mr. Maboho of him having performed duties and mandatory responsibilities in the position of chief magistrate that had become temporarily vacant during the period of 1 July 2007 until 17 August 2010, and he was improperly prejudiced by performing duties of a chief magistrate without being remunerated. Thus, to remedy this maladministration and improper prejudice, the acting Director General must within 60 working days from the date of this report calculate and pay an applicable acting allowance in line with the legally prescribed period. The next report is that of Pratt versus the South African Reserve Bank, report number 105 of 2019-2020. The allegations of maladministration and improper conduct at the South African Reserve Bank and the First Rand Bank were investigated. The investigation followed a complaint by Ms. Anya Pratt. The complaint was initially lodged by Ian Levitt attorneys on behalf of the complainant on 21 April 2016. The complainant later submitted a revised complaint during April 2017. In essence, she alleged, among other things, that the SAB issued exchange control rulings to authorize dealers, setting out the conditions, permissions, and limits applicable to transactions in foreign exchange which may be undertaken by authorized dealers, as well as details of related administrative responsibilities. That FirstRand, in exercising their powers, rights, and obligations under the regulations and exchange control rulings, is exercising a public function, and that the public protector is empowered to investigate FirstRand. That FirstRand unlawfully marketed and sold loop structures to its high wealth clients as a purported legal and legitimate way in which such clients could export funds from South Africa offshore. This included the complainant, who was incorrectly informed and advised by FirstRand that the loop scheme devised for her was a legal and legitimate way in which she could export funds offshore. After analyzing the complaint, it was decided to investigate whether South African Reserve Bank acted improperly and or abused its power in dealing with Ms. Pratt's complaint against FirstRand Bank, and whether the public protector has jurisdiction to investigate allegations of Ms. Pratt against the FirstRand Bank. Findings could not be made as the matter was dealt with in court, and the public protector did not enjoy jurisdiction over the FirstRand Bank. On these grounds, the investigation was closed. Followed by the report of Moodley versus the University of Pretoria, report number 127 of 2019-2020. The allegations of undue delay by the University of Pretoria to address queries raised by Ms. P.T. Moodley were investigated. The complainant is a student at the University of Pretoria, alleging that the university unduly delayed to address queries that she raised with them. In the complaint, she alleges that she made a query to the university for quality assurance in respect of the reasonableness of the criteria for the property law SAR 310 assignment. She complained about the lack of transparency in engaging to objectively address her concerns about the sudden unexplained downturn in her performance after she actively and critically engaged with an issue such as the reasonableness of an assignment. She requested a referral of the ISR 310 assignment for independent assessment and or moderation in order to address any perceived bias or feeling of victimization by the complainant. The university has allegedly not constructively engaged her with a view to addressing the concerns raised about the treatment of and seeming bias against her. After analyzing the complaint, it was decided to investigate whether the university addressed the complainant's inquiry relating to the reasonableness of the criteria used for the property law SAR 310 assignment, and further whether they failed to provide her with a model answer that she requested for this assignment. We also looked into whether the university failed to have transparent engagements with the complainant to address their concerns regarding reasonableness of an assignment, which resulted in a downturn in her performance. In addition, it was looked into whether the university failed to attend to the complainant's request for her ISR 310 test prescript to be independently assessed or moderated in order to address any perceived bias or feeling of victimization, wherein she was of the opinion that she was marked more stringently than other students. It was found that the allegations to be unsubstantiated. The reasons thereof are detailed in the report. During the investigation in this particular case and other cases against the university, the following observations were made and directed on the following remedial actions to be taken, which, in the opinion of the public protector, will enhance the manner in which the university functions and operates when dealing with complaints received from students, parents, and personnel within the university structures. The university needs to maintain complaint files as well as have clear procedures for receiving, reviewing, and evaluating complaints, preferably by establishing a formal designated independent complaints unit that will serve as an ombudsman office. The complaints need to be investigated in a uniform and timely manner. Having this independent unit will instill confidence and give the impression of a separation of powers approach, protecting the independence and integrity of the complaints which are to be investigated. Having a designated complaints unit will circumvent an influx of cases that the Office of the Public Protector receives against the university. Persons will be able to report matters directly to the complaints unit or ombudsman instead of approaching the Office of the Public Protector as first instance. In the matter of Van der Steen versus David Kruiper Local Municipality, report number 128 of 2019-2020. The Public Protector investigated allegations of improper conduct and maladministration relating to the appointment of staff by the David Kruiper Local Municipality in 2016, following a November 2016 complaint from Mr. P.T. Van der Steen, a member of the council of the municipality. He alleged the municipality appointed Mr. S.P. May, Ms. R. George, Mr. D.Z. Ntlanganiso, and Mr. Desmond van Wyk in 2016 without the relevant posts being advertised and interviews being held. In essence, Mr. Van der Steen alleged that the appointments were not in accordance with the relevant laws and prescriptions relating the appointment of staff of the municipality, and that the conduct of the municipality in this regard was improper, constitutes maladministration, and resulted in irregular expenditure. After analyzing the complaint, it was decided to investigate whether the temporary appointments of Mr. S.P. May, Ms. R. George, and Mr. D.Z. Ntlanganiso by the municipality in 2016 were in accordance with the relevant laws, the prescripts regulating the recruitment and selection of staff of the municipality, and if not, whether the conduct of the municipality was improper, constitutes maladministration, and resulted in irregular expenditure. It was found that these allegations are substantiated. The vacant positions were not advertised, and the recruitment and selection process prescribed by the policy were not followed. The remuneration paid to Mr. May, Mr. Ntlanganiso, and Ms. George from the date of their appointment accordingly constitutes irregular expenditure as contemplated by the NFMA. To remedy this improper conduct and maladministration, it was directed that the municipal manager must take appropriate steps in respect of disciplinary action against the officials that were involved in the irregular appointment of Mr. May, Mr. Ntlanganiso, and Ms. George, in terms of the disciplinary procedure of the municipality envisaged in the Municipal Systems Act and the NFMA within 30 business days from the date of this report. The municipal manager must also institute proceedings for the judicial review of the irregular appointment of Mr. May, Mr. Ntlanganiso, and Ms. George in terms of the relevant prescripts within 30 days from receipt of this report. In the matter of Anonymous versus Magalakwena Local Municipality, report number 1 of 2020-2021. The allegations of irregular appointment of Mr. P.J. Mashemaite to a position of Deputy Manager Corporate Services by the Magalakwena Local Municipality in Limpopo were investigated. This followed an anonymous complaint received on the 11th of November 2018. In the complaint, it was alleged that the municipality advertised 3 different posts, including that of Deputy Manager Corporate Services in the Noordelijke Nis Northern News newspaper dated 28 October 2016. The minimum requirements for the post of Deputy Manager Corporate Services were a bachelor's degree or a public administration law equivalent qualification. In terms of the recruitment, The incumbent ought to have had a minimum of 4 to 5 years relevant experience at middle management. The applicant also needed to be computer literate and have a driver's license. According to the complainant, the appointed candidate, one Mr. P.J. Mashamalite, applied for the position in question and was shortlisted, even though he did not meet the minimum requirements for the post. He is also alleged to have not attached copies of his qualifications as required by the advert. However, the municipality allegedly went on to interview and appoint him to the position. After analyzing the complaint, it was decided to investigate whether the municipality irregularly shortlisted and appointed Mr. Mashamalite to the position of Deputy Manager of Corporate Services without following proper recruitment processes, and whether the complainant and other applicants suffered prejudice as a result of the alleged irregular appointment of Mr. Mashamalite. It was found that the municipality irregularly shortlisted, interviewed, and appointed Mr. Mashamalite to the position of Deputy Manager Corporate Services without meeting the minimum requirements. It was also found that the complainant and other applicants suffered as a result of the irregular appointment of Mr. Mashamalite. To remedy this improper conduct and maladministration, it was directed that the executive mayor take appropriate steps in respect of disciplinary action against the acting municipal manager, Mr. Mulala, for the irregular appointment of Mr. Mashamalite as the Deputy Corporate Manager, Corporate Services, in terms of the disciplinary procedures of the municipality envisaged in Section 67, subsection 1H of the Municipal Systems Act and Section 171, subsection 4 of the MFMA, within 60 business days from the date of receiving this report. The executive mayor must also conduct an analysis and evaluation of Mr. Mashamalite's qualifications, experience, and competence against the requirements and job description of the position of an acting divisional head, parks and recreation that he occupied within 60 business days from the date of receiving this report. The executive mayor must further submit a report to the municipal council within 60 days of the date of receiving this report for a decision on the matter, and take appropriate steps to institute proceedings for the judicial review of the irregular appointment of Mr. Mashamalite within 60 business days from the date of receiving this report. The municipal manager must consider the report of the executive mayor referred to above and take a resolution on the matter within 60 business days from the date of receiving this report. In the matter of Van Schalkwyk versus the City of Tshwane, report number 2 of 2020-2021, the allegations of irregular billing and improper prejudice by the City of Tshwane Metropolitan Municipality were investigated against Ms. Gelde Van Schalkwyk. Ms. Van Schalkwyk alleged in her December 2018 complaint that the city unduly delayed to provide her with accurate billing, and that the undue delay caused her to suffer improper prejudice. She alleged that her daily water consumption escalated to 26.52 kiloliter per day on 22 July 2015 from the regular 4.74 kiloliter per day. Her last statement was recorded on the 2nd of July 2015. On the 2nd of October 2015, 92 days later, she received a statement of account with actual water readings of an amount of 167,981. Upon realizing that the water usage was out of her normal monthly water consumption, she considered other reasons for the excessive consumption. The water meter was situated almost 40 meters in the street behind the property. After her initial investigation, she obtained services of a plumber who does leak detection on properties. The leak detection was done on the 4th of November 2015, and the leak was found and repaired. The leak was underground, hence she had no knowledge thereof. She informed the office that it was only as a result of the city's actual water consumption invoice of October 2015, that she became aware of the leak. She submitted further that she received accurate billing from the city. If she had received accurate billing from the city rather, she would have realized that there was a leak on the property and she would have repaired same within 33 days. She complained that she ended up with a water bill of 258,796 rands during 14 December 2015. She lodged a dispute with the city and received 50% relief, which left her with a huge bill in excess of 130,000 to pay. After analyzing the complaint, it was decided to investigate whether the city had unduly delayed to provide Ms. Van Schalkwyk with accurate water billing, and if so, whether her excessive water account could have been avoided if regular billing was taken, and whether she suffered prejudice as a result of the conduct of the city. Both allegations were substantiated. The city failed to issue the complainant with accurate water consumption bills. She was provided with estimated readings instead of actual readings. The accurate bills rather were issued to her on the 12th of January 2015 and 2 October 2015. The city's officials recorded monthly water meter readings but failed to provide the accurate billing to the complainant. Had the city issued accurate and regular billings to the complainant, she could have attended to the invisible and underground water leakage on her property and avoided the excessive billing. It was established that the water meter was not situated on Ms. Van Schalkwyk's property, but nearly 40 meters away. The water meter is situated in the street behind her. The leak was on her property but underground and therefore not visible to her. As a result, she could not have known or realized that water was being lost. Had the city provided regular and accurate accounts, she could have identified the water loss and rectified it. The nearly 7 months period that it took the city to provide accurate and regular billing prevented Ms. Van Schalkwyk from establishing that she had an internal leak on the property and delayed her from rectifying the leak. The city also charged her interest on the account in the amount of approximately 30,000 rands, and the leak water was also charged at the highest step of the sliding scale tariff. The city has a discretion to provide financial relief or to write off the account. Even though the city gave Ms. Van Schalkwyk a 50% discount, she still suffered financial prejudice amounting to approximately 130,000 rands for water loss through the undetected leakage. To remedy this improper conduct, maladministration, it is decided to direct the city manager to, within a month of the date of receipt of this report, tender a written apology to Ms. Van Schalkwyk for the city's failure to provide her with accurate and regular statements for her account. The city manager must also prepare a submission setting out the reasons of the debt to council, including this report, for consideration for the outstanding debt of this account to be written off in terms of the city credit and debt policy. In the matter of Oma and others versus the Standing Committee for Refugee Affairs, report number 3 of 2020-2021. It was the allegations of undue delay by the Standing Committee for Refugee Affairs, commonly known as SCRA, in finalizing the adjudication process of certification applications was investigated. This was a systemic investigation following receipt of numerous complaints relating to the alleged undue delay by the SCRA to process and adjudicate on the certification applications. The investigation focused on whether the SCRA unduly delayed in processing and adjudicating of the complainants' applications made in terms of Section 27C of the Refugees Act 130 of 1998 and its regulations, and whether the complainants were improperly prejudiced by the conduct of the SCRA. It was found that indeed the SCRA unduly delayed the processing and adjudication of the complainant's application made in terms of Section 27C of the Refugees Act 130 of 1998 and its regulations. The investigation revealed that the SCRA has systematic administrative deficiencies in processing and adjudicating the complainant's applications made in terms of Section 27C of the Refugees Act and its regulations. The SCRA is not sufficiently resourced and funded to handle the volume of work it is currently dealing with. It takes very long for the Department of Home Affairs to respond to the request from the SCRA to be furnished with the file contents of their applications. The archives and registry where the refugee files are being kept is far, and this adds on to the constraint that the SCRA has. For an example, the SMT referred to one case where it requested file contents from the refugee office in 2010. And by the 3rd of August 2018, they had not received the file contents. The SCRA, supported by the minister, conceded to the findings. It was further found that the complainants were improperly prejudiced by the conduct of the SCRA. Had the SCRA adjudicated the complainant's applications timeously, they would have qualified to immediately apply for the permanent residence permit. After 5 years of being issued with the permanent residence permits, the complainants would probably have been eligible to apply for naturalization in terms of Section 5, subsection 1C of the Citizenship Act number 88 of 1995. In terms of Section 19, subsection 3 of the Constitution, every citizen has the right to vote in the elections. The complainants who would have been naturalized South Africans would have been eligible to participate in both the local government election as well as the national elections. Regarding remedial action, the Minister and the Acting Director General must, within 21 working days of the issuing of this report, ensure that the chairperson of the SCRA and the current 2 members of the SCRA commence working on the backlog to finalize all certification, litigation, and withdrawal of status application. The minister must, within 45 working days of the issuing of this report, capacitate the SCRA with the appointment of an additional 4 members to enable it to be equal to the amount of the work that it receives. The acting DG must, within 60 working days of the issuing of this report, ensure that all refugee records predating to 2016 are loaded onto the NIS and enable the backlog team to discharge its functions without delay. The Acting Director General must, within 45 working days of the issuing of this report, capacitate the SCRA by appointing additional administrative support staff to enable it to be equal to the amount of work that it receives. The Acting Director General must, within 30 working days from the date of receipt of this report, consider appointing into positions of refugee status determination officers legally qualified officials to ensure that the cases reviewed by the SCRA are minimal. The chairperson of the SCRA must, within 30 working days from the date of this report, apologize in writing to the complainants for the delay in adjudicating their matters and give them the dates upon which their matters will be finalized. The chairperson of the SCRA must ensure that going forward, all new certification applications are finalized within 6 months from the date of receipt by the SCRA as undertaken by the SCRA. The chairperson of the SCRA must ensure that going forward, all new applicants whose applications are not finalized within 6 months from the date of receipt by the SCRA are given full progress report on the status of their application every 6 weeks until their applications are finalized. In the matter of Smith versus Kai Harib Local Municipality, report number 6 of 2020-2021, the allegations of improper conduct and maladministration in relation to the appointment of Mr. Willem Ryan as Water Progress Controller Class 1 by the Kaigarib local municipality in the Northern Cape were investigated. The investigation followed a July 2016 complaint by Mr. I.R. Smith, who alleged improper conduct and maladministration by the municipality in relation to the appointment of Mr. Willem Ryan as Water Process Controller Class 1. Following an analysis of the complaint, it was decided to look into whether the temporary appointment of Mr. Ryan as Water Process Controller Class 1 by the municipality with effect from 1 July 2016 to 28 February 2017 was in accordance with the relevant laws and prescripts regulating the recruitment and selection of staff of the municipality, and if not, whether the conduct of the municipality was improper, constitutes maladministration and resulted in irregular expenditure. It was also investigated whether the permanent appointment of Mr. Ryan by the municipality as process controller class 1 with class 2 rather, from effect from 1 March 2017 was in accordance with the relevant laws and prescripts regulating the recruitment and selection of staff of the municipality. And if not, whether the conduct of the municipality was improper, constitutes maladministration and resulted in irregular expenditure. It was found that all the allegations were substantiated. To remedy this improper conduct and maladministration, it was directed that the municipal manager take appropriate steps in respect of disciplinary action against the officials that were involved in the irregular appointment of Mr. Ryan in terms of the disciplinary procedures of the municipality envisaged in the Municipal Systems Act and the MFMA within 60 business days from the date of this report. The municipal manager must further institute proceedings for the judicial review of the irregular appointment of Mr. Ryan within 60 business days from the date of receipt of this report. In the matter of Dieka and others versus Directorate Priority Crimes Investigation, report number 7 of 2020-2021, the allegations of improper conduct and maladministration by the Directorate Priority Crime Investigation, known as DPCI, of the South African Police Service relating to the appointment of staff was investigated. The investigation was based on a complaint lodged on 28 January 2019 by Detective Warrant Officer M. Dieka, Detective Warrant Officer N. Vumazonke, Detective Warrant Officer N. Mteja, and Detective Sergeant M. Sonjani of the DPCI. They alleged that the DPCI conducted an improper recruitment and selection process in filling several vacancies of warrant officer, lieutenant, and captain, resulting in them not being appointed and therefore prejudiced. On analyzing the complaint, it was decided to investigate whether the recruitment and selection process followed by the DPCI for the post of lieutenant under reference number DPCI ACI EC2 complied with the South African Police Service National Instruction 6 of 2005. Whether the recruitment and selection process followed by the DPCI for the post of captain under reference number DPCI EC 447 of 2016 complied with the SAPS National Instruction 6 of 2005, and whether the recruitment and selection process followed by the DPCI for post of warrant officer under reference number DPCI EC 286 of 2016 complied with the SAPS National Instruction 6 of 2005. It was decided to close this investigation. This was because the Independent Police Investigation Directorate is currently investigating alleged fraudulent documentation sent to the complainant relating to the post of lieutenant under reference number DPCI ACI EC2, and as such, the office could not make a determination on the matter. Further, General Libya has already implemented the appointment of Warrant Officer N. Mtegwa and Warrant Officer M. Dieka to the rank of captain as redress to their complaint with effect from 1 April 2017, which was the issue under investigation under reference number DPCI EC 447 of 2016. In addition, the records of the selection panel clearly indicate that Sergeant Sonjani was rated as 9 out of 11 candidates and was therefore not recommended for the post reference number DPCI EC 286 of 2016. Although the then national head of DPCI did not sign the panel recommendation document, the subsequent appointment of Sergeants Kem and Mulwandle as the two highest scoring candidates were not irregular, as such administrative functions may be lawfully delegated by the national head. Lastly, on 19 August 2020, the investigating team consulted with all complainants to discuss the discriminatory letters issued on 13 August 2020, informing them of the intention to close the file. During this consultation, all indicated their satisfaction with the outcome and had no further inputs to make. I now wish to hand over to the public protector to then take us through the rest of the report.
Thank you, DPP. Thank you so much. The investigations which we conducted under good governance and integrity relates to the complaint which was lodged by Mr. Jack Carlson, the member of provincial legislature in the Free State, complaint against the former premier, Mr. Elias Mahashule. The investigation was prompted by a complaint from the DA MPL, as I've indicated, and alleging that the former premier misled the provincial legislature in his written response to questions from members of the legislature. The first instance relates to the involvement of the Office of the Premier in the funeral arrangements of the late MEC of Health, Ms. Ngubentombi, may her soul rest in peace, while the second concerned a forensic report in connection with the appointment of Letlaka Communications by the Office of the Premier. According to Honorable Jackelson, in his reply to the question paper of 20 November 2013 regarding the funeral cost of Ms. Ngubentombi, Mr. Mahashule asserted that the extent of involvement of the Office of the Premier was merely to inform relevant ministries, departments, and persons of the details of the official funeral. Honorable Jankelson argued that in a letter from the former Director General in the Office of the Premier to the Municipal Manager of the Fezile Gabi District Municipality, the extent of involvement included instructing inter alia the municipality to undertake costs which would be refunded by the provincial government, specifically the Department of Public Works and Infrastructure. Accordingly, the complainant contended that the former premier blatantly misled the legislature in his reply concerning the involvement of his office in the funeral arrangements, as well as the commitment by his office to ensure that the provincial government refunds the municipality. The complainant also stated that during a sitting of the legislature on 21 May 2015, Mr. Mahashule denied any knowledge of a National Treasury report regarding the appointment of Letlaka Communications by his office. This was in reply to questions relating to the report. He argued that in two replies from former Minister of Finance on 15 November 2013 and 14 August 2015, respectively, Mr. Mahashule was made aware of the report and refused to act on the recommendations by the minister to take criminal action against indicated individuals. The former premier was alleged to have also denied knowledge of the report and recommendations of the ministers in a reply dated 30 September 2015. In the investigations which we've conducted about these allegations, we looked into the following three issues: whether Mr. Mahashule, in his reply, in his capacity as former premier of the Free State, made a misleading statement to the provincial legislature in his response to the question relating to the funeral arrangements of the late Miss Ngubentombi, and in so doing violated the ethics code. The second question, whether Mr. Mashinini, in his capacity as the MEC for Public Works and Infrastructure, made a misleading statement to the provincial legislature relating to the funeral arrangements of the late Ms. Ngubentombi, and in so doing violated the ethics code. And the third issue we investigated related to whether Mr. Makashula made a misleading statement to the provincial legislature in his response to questions posed in the legislature relating to the findings and recommendations made in the GJL Forensic Services Investigation Report, as well as the recommendations made by the Minister of Finance in respect of allegations of irregularities associated with the contracts entered into between his erstwhile office and the Litlaka Communications, thereby violating the ethics code. My investigation revealed that the former premier did not mislead the legislature in his reply concerning the involvement of his office in the funeral arrangements, as well as the commitment by his office to ensure that the provincial government refunds the municipality. The allegation is insubstantiated. In his reply, Mr. Makashule confirmed that what was already known, which was that the Department of Public Works and Infrastructure would be responsible for the expenditure of the funeral, that the extent to which his office was involved in the arrangements was informing relevant ministries, departments, and persons of the details of the official provincial funeral as declared by the presidency. His office's involvement was also in terms of the ministerial handbook to announce the demise of Ms. Ngubentombi and instruct those concerned to commence with the immediate implementation of the procedures in the policy, and lastly, to advise the complainant to direct his questions relating to cost to the responsible department. As alluded by the complainant, the former premier's response may have been somewhat vague and to the extent inadequate, but cannot be regarded as evasive or misrepresenting the facts, and as such, it could not be established that the former premier deliberately or inadvertently misled the legislature. I found that Mr. Mashinini, the MEC, misled the legislature in response to the questions of the complainant relating to the funeral arrangements of the late Ms. Ngubentombi. In his reply to the question, Mr. Jackelson, on whether his department will refund the Fezile David District Municipality for the cost incurred for the funeral of Ms. Ngubentombi, MEC Mashinini stated in a written reply that his department did not commit to refund the costs incurred for the funeral to the municipality. Contrary to this assertion, the DG in the Department of the Premier instructed the municipality to liaise with the Public Works and Infrastructure Department with regard to expenditure relating to logistical arrangements for the funeral of the late MEC. In addition, the head of Public Works and Infrastructure Department, Mr. Sioke, approved a submission by the Chief Financial Officer, which stated specifically that the cost of the funeral was to be borne by the Department of Health and Public Works and Infrastructure, and that the municipality would have to claim against the provincial government for logistical arrangements for the funeral. Mr. Mashinini stated that he responded to the complainant with information as received from the head of department, and that he was later informed by the former premier that his reply to the question was factually incorrect. He submitted that although the information he provided was incorrect, he did not willfully mislead the legislature in breach of the ethics code. I found that by providing the inaccurate information to the legislature, Mr. Mashinini inadvertently misled the legislature and therefore breached Section 136(1) and Section 133(3)(a) of the Constitution. The MEC also breached paragraph 3.1 and 3.7 of the Code of Conduct and ethics for members of the provincial legislature. Lastly, I found that Mr. Mahashule did not mislead the provincial legislature by denying any knowledge of the report by GJL Forensic Services, as well as the recommendation of the Minister of Finance. It was established during the question and answer session in the provincial legislature that a misunderstanding occurred between members concerning the National Treasury report. 3 versions of the report were in circulation. One of the versions was leaked. The former Premier's responses to questions was formulated with a view to ascertain which version of the report was being referred to in light of the possibility that it may be the leaked version. In this regard, his reply cannot be construed as misleading in any way, given the context in which it was provided. Moreover, it was established that the former Premier acknowledged rather than denied having access to the National Treasury report and therefore could not be found to have misled the legislature. It was established that the former Premier considered to deny having knowledge of the recommendations to lay criminal charges against officials implicated in the National Treasury report by the former Ministers of Finance during a sitting of the legislature. When the aforesaid recommendations were communicated in the legislature, the former Premier did not have access to the report until the following year. Upon receipt of the report, the former Premier communicated his discontent with the investigation process as well as the JGL Forensic Services, which conducted the investigation. Following the failure of the National Treasury to consider and examine these areas of dissatisfaction, the former Premier escalated his discontent to the former Minister of Finance, Mr. Nene, advising him that due to these unresolved issues and other shortcomings of the report, he was unable to lay criminal charges against the officials. Accordingly, it could not be established that the former Premier deliberately or inadvertently misled the President or the Premier or, in fact, the legislature, as the case may be. Regarding the remedial action, the current Premier of the Free State must take cognizance of the findings of the violation of the Constitution and the Ethics Code by MEC Mashinini to ensure that such conduct is not repeated and take appropriate corrective action to prevent recurrence. In this instance, this is to ensure that whenever the Premier, the MECs and the Premier, they respond to questions in the legislature, they was an investigation on allegation of maladministration and improper conduct in connection with the failure by the PIC to implement the recommendations of Board of Forensics and Investigative Accounting Limited's forensic investigation report. The investigation followed a May 2016 complaint by the leader of UDM and Member of Parliament, Mr. Holomisa. Mr. Holomisa based his request for an investigation on the recommendations made in the Board of Forensic and Investigating Accounting. There was a report which was issued 7th August 2015 following their investigation, and that was relating to the involvement or impropriety of the employees relating to corporations investment of 75 million rands. He requested that an investigation be conducted with a view to determine why PIC is not implementing the report, since the PIC is entrusted with managing public monies on behalf of government employees, judges, members of parliament, and others who are paid from the public purse. So after analyzing the complaint, we decided to look into whether the PIC implemented recommendations made in the Board of Forensic and Investigative Accounting report, and if not, whether such failure by the PIC to implement the recommendations caused the corporation to incur irregular expenditure. We found that the allegation that the PIC did not implement the recommendations of the Kobodo report is not substantiated. Information obtained during the investigation indicated that Mr. Matavo was subjected to a disciplinary process for his failure to execute his duties with due diligence in connection with a SEC oil transaction as recommended in the Kobodo draft forensic investigation report. This information also indicated that the PIC subscribed to 111 million 111 million and 942 ordinary shares at a share price of 67 rands, which amounted to approximately 75 million, which illustrates that neither the PIC nor GEPF incurred any losses. It was noted that the PIC obtained legal advice from its legal department in connection with a recommendation that the corporation must consider obtaining a legal opinion on the appropriate steps to be taken against an employee who traded in SEC oil shares revised its code of ethics policy as well as its disciplinary policy with a view to encouraging its directors as well as its employees at all levels to apply due diligence procedures with a view to eliminating as far as reasonably possible the risk of its clients incurring losses due to inter alia theft, fraud, dishonest act, poor administration, negligence, professional misconduct, or culpable omissions. In the circumstances, I'm inclined to conclude that the PIC implemented the recommendations made in the Kobodo Forensic Investigative and Accounting Forensic Investigation Report. As a corollary to this, I am not making a finding and taking any appropriate remedial action as envisaged in the Constitution and the Public Protector Act. The next report relates to Van Dalen and another versus Department of Energy, report number 148 of 2019-2020. Unfortunately, we're still dealing with the matters which were launched prior 2016. And was an investigation of maladministration and improper conduct in connection with the decision by the former Minister of Energy, Ms. Tina Jumat-Peterson, to approve the sale of 10 million barrels of strategic fuel reserves held by the Strategic Fuel Fund Association. This followed complaints lodged by the DA, a Member of Parliament, Mr. Van Dalen, and the FF Plus, Member of Parliament, Mr. Alberts, on 31 May 2016 and 1 June 2016, respectively. They allege that the decision by Ms. Jumat-Peterson, who was the Minister of Energy at the time, to approve the sale of 10 million barrels of the energy strategic fuel reserves held by the SFF in a closed bidding processes in 2015 and 2016, which was kept as South Africa's reinsurance policy in the event of a sudden fuel crisis, was irrational and in contravention of the provisions of Section 54(2)(d) of the Public Finance Management Act, as well as the Central Energy Fund Act. Based on an analysis of the complaints, as well as media reports covering concerns raised in connection with the manner in which the disposal of the strategic fuel reserves was conducted and the information that came to my attention from various sources, the following two issues were identified for investigation. Whether the decision by the former Minister of Energy, Ms. Jumat-Peterson, to approve the sale of 10 million barrels of the strategic fuel reserves held by the SFF was rational, and if not, whether the conduct constituted maladministration and improper conduct, and whether the sale of 10 million barrels of strategic fuel reserves held by SFF was conducted in accordance with legislation regulating the disposal of significant assets and any other prescripts applicable to the SFF, and if not, whether that conduct constituted maladministration and improper conduct. At the time of the disposal of the strategic fuel fund, fuel reserves, the SFF did not have a policy regulating the rotation and sale of the fuel reserves. It is therefore essential that SFF develops a rotation and sale strategic stock policy and submits it to the SFF Fund Association Board of Directors for consideration, whereafter it can be submitted to the Minister of Mineral Resources and Energy. Following the lodging of complaints by Van Dalen and Alberts, Mr. Gamete and the former chairperson of the Central Energy Fund Group Board of Directors, Mr. Riaz Jawoudin, resigned from their positions with immediate effect following a debate over an unauthorized bid for Chevron SA by the Strategic Fuel Fund Association, without seeking nor obtaining permission from the shareholder as required by the provisions of the PFMA. The former chairperson of the Central Energy Fund Group Board of Directors, Mr. Lubo Makasi, has filed an application under case number 21771 of 2018 in the Western Cape Division of the High Court, seeking an order setting aside the decisions to conclude agreements and transactions entered into between the Strategic Fuel Fund Association and service providers following the sale of the Strategic Fuel Fund reserves. The sale of the Strategic Fuel Fund of fuel reserves is also a subject of an advanced investigation currently conducted by the South African Police Services Directorate of Priority Crimes Investigations, and they've confirmed as well that they are busy with the investigation. So in terms of Section 7(1)(a) of the Public Protector Act, the Public Protector had to determine on the basis of what was found from the preliminary investigation how the matter should be dealt with. The issues raised by the complainants are currently a subject of litigation in the Western Cape Division of the High Court, and I took a conscious decision to allow the judicial process to take its course and for the court to make a competent pronouncement on the matter, which the public protector would by law be bound to it in any event. Further, that the pursuance of the matter and remedial action that I may consider should adverse findings be made from a further investigation will serve no judicious purpose on the basis that the accounting authority and the chief executive officer of the SFF would not be able to take action against the former CEO of SFF Association, Mr. Gamete, who since he is no longer in the employ of Strategic Fuel Fund Association. I'm referring this matter in terms of Section 64C, Roman figure 2 of the Public Protector Act to the Directorate for Priority Crime Investigations to determine whether the former CEO of Strategic Fuel Fund Association, Mr. Sibusiso Gamete, or any person may have committed an offense. In light of the above, I'm neither making any finding nor remedial action, which the report only consists of the observations which we've made, that there is no policy and that policy will have to be developed. The next matter is Mutobi versus Northwest Parks Board, report 153 of 2019-20. We investigated allegations of maladministration, improper prejudice by the Northwest Parks Board in relation to the suspension and subsequent dismissal of former CEO, Mr. Mutobi. This was after he made a protected disclosure as contemplated in the Protected Disclosure Act. The Northwest Parks Board is a Schedule 3 public entity established in terms of the Public Finance Management Act and the Public Service Act. Mr. Mutobi lodged a complaint with my office on 21 February 2019, alleging that he was victimized by the Northwest Parks Board after he made the protected disclosures, resulting in suspension and subsequent dismissal. In the main, he alleged that the Parks Board, in protecting a then sitting member of its board, Dr. Makome, and supported by the former MEC Tlhape, improperly suspended and subsequently dismissed him in retaliation to a protected disclosure he had made to a member of the Executive Council regarding suspected corruption, conflict of interest, irregularities within the Parks Board. The investigation further dealt with the allegation that the Executive Council Cluster Committee on Economic and Infrastructure Development failed to implement the resolution following the submission of a memorandum recommending implementation of the legal and financial due diligence report of 2007 by MAPE Incorporated attorneys. Following a thorough analysis of the complaint, we decided to investigate whether the Northwest Parks Board improperly handled Mr. Mutobi's protected disclosure, which he made in terms of the protected disclosure to MEC regarding the corruption, conflict of interest, irregularities, and resulting in his suspension and subsequent dismissal. We also looked into whether the EXCO of Aid Cluster Committee failed to implement the resolutions flowing from the submission by the complainant of a memorandum dated 12 June 2017, recommending the implementation of the legal and financial due diligence report, which is the MAPE attorney's report. In the circumstances, Mr. Mutobi was prejudiced as a result of the conduct of the Parks Board. I found that indeed the Parks Board improperly handled Mr. Mutobi's protected disclosure, which was made to the MEC and regarding suspected corruption, conflict of interest, and irregularities within the Northwest Parks Board, resulting in his suspension and subsequent dismissal. Also found that the EXCO Aid Cluster Committee failed to implement the resolutions following from the submission dated 12 June 2017. Mr. Mutobi recommending the implementation of this MAPE report. Although evidence before me clearly indicates that Mr. Mutobi was dismissed as a result of the disclosure, I cannot turn a blind eye to the fact that through a settlement agreement concluded at the CCMA on the 7th of August 2018, he acceded to the substantive fairness of his dismissal, meaning that he did not dispute the charges preferred against him. He did not advance any reasons why he signed the settlement agreement, despite the fact that he was not present at the internal disciplinary hearing that resulted in his dismissal, or the fact that he had raised a protected disclosure as a reason for his dismissal. It further came to my attention that he elected to proceed with the hearing at the CCMA on a day when his legal representative was not available. Although in signing the settlement agreement, he acceded to having committed misconduct, it is my finding that the disclosure that he has made and not misconduct that he allegedly committed was the dominant and most likely cause of the charges being brought against him and the subsequent dismissal. In terms of Section 187(1)(h) of the Labor Relations Act, such a dismissal is regarded as automatically unfair and would ordinarily invoke the remedies provided for in Section 193 of the LRA, which includes either reinstatement, re-employment, or compensation. The compensation awarded to an employee whose dismissal is found to be automatically unfair must, in terms of Section 194 of the LRA, be just and equitable in all the circumstances, but must not be more than equivalent of 24 months remuneration at the employer's rate of remuneration on the date of dismissal. Employee's rate of remuneration at the date of dismissal. I'm, however, bound by the rule of law to arrive at a sound and qualified finding. I'm also bound to be mindful of what is fair and just under the circumstances in executing my mandate in terms of the Constitution of the Republic as well as the Public Protector. I had to holistically take into consideration all the information gathered throughout the investigation. It is of importance for me to reiterate that my investigation did not seek or attempt to confirm the charges against Mr. Mutobi as the process had already unfolded at the CCMA. I, however, had to satisfy myself in assessing the weight that the charges carry and extent of the impact they may attribute to my findings on this investigation. I'm therefore unable to establish an opportunity of remitting the matter for a re-hearing and or recommend reappointment or reinstatement, as this might result in an unintended review of the CCMA ruling. As for the settlement agreement itself, including any other matter that arose within the CCMA, I express no further view of my own self to advise that Mr. Mutobi may approach the Labour Court for a judicial review should he still feel prejudiced by the same. It is my well-measured view that my decision should not be seen as a pronouncement on a question of law in the stringent sense of the word, but rather a pronouncement of wrongdoing, especially on the part of the organ of state. As part of the remedial action, I direct the MEC of Rural, Environmental and Agricultural Development to ensure that the resolutions taken on 12 July 2017 at the Executive Council meeting 5 of 2017 held at Tax Hotel in Tau in respect of the submission on due diligence report recommendations are implemented within 60 working days from date of this report. In addition, the Premier must ensure that the remedial action is actioned accordingly. I think this report will also refer it to the PCI, especially to investigate any criminal conduct which might have transpired on those alleged corruption. The next matter is Freds and Hunter Local Municipality, which is the report number 4 of 2020-2021. The investigation was on investigation of improper conduct and maladministration by the mayor, Mr. Swartz, and Councillor Divier, host Alexandra of Hantam Local Municipality in the Northern Cape, relating to travel and subsistence allowance paid to them in May 2017. In a December 2017 complaint, Dr. Fritz alleged that the mayor and the councillors misappropriated public funds by utilizing the travel and subsistence allowances that were paid to them for official purposes to attend the provincial conference of the ANC. According to Dr. Fritz, the mayor and councillors were invited to a provincial social development department workshop on its social relief program. The workshop was scheduled to take place between 11 and 15 May 2015 in Colesberg. The dates of the workshop coincided with those of the ANC conference. Dr. Fritz further alleged that the workshop that the mayor and councillors were invited to didn't take place. The mayor and the councillors attended the ANC conference instead before making their way home. It was Dr. Fritz's contention that the mayor and the councillors attended the ANC conference at the expense of the ratepayers under the pretext of attending the workshop. Upon analyzing the complaint, I decided to whittle down the investigation to two issues. The one was whether the mayor and the councillors acted in accordance with the relevant laws and prescripts regulating S&T allowances the municipalities paid in respect of the trip they undertook to Colesberg in May 2017. The other issue was whether their conduct was proper, constituted maladministration, and resulted in the misappropriation of public funds. We found that indeed Mayor Swartz and councillors De Beer, Hoos, and Alexander did not act in accordance with the relevant laws and prescripts regulating S&T allowances the municipality paid in respect of their trip to Colesberg. Mayor Swartz and councillors were paid 2,007 each, while Councillor De Beer was paid 6,000 rands, 324.32 cents. They did not inform the acting municipal manager about the cancellation of the workshop. They also attended the ANC conference whilst in Colesberg at the expense of the state and failed to reimburse the municipality for the amount it paid them or portion thereof. Their conduct was improper, constituted maladministration, and resulted in the misappropriation of public funds, fruitless and wasteful expenditure, as contemplated in the Municipal Finance Management Act. It may also constitute a breach of Code of Conduct contemplated in the Local Government Municipal System Act. This conduct constitutes improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. To remedy this, I direct the MEC of Cooperative Governance, Human Settlements and Traditional Affairs in the province to appoint a person or committee in terms of item 14.4 of the Code of Conduct for councillors to investigate whether the mayor and the councillors breached the code of conduct, and if so, take action as contemplated in item 14.2 against them. In addition, I direct the municipal manager to take appropriate steps in terms of the MFMA to recover the SNT allowance the municipality paid to the mayor and the councillors for the period 11 to 14 May 2017. All these directives must be effected within 60 business days from date of this report. I look forward to a constructive engagement with these findings from all the implicated parties. I always say adverse findings are means to fix any gaps in the system so that we avoid the recurrence in the future. Remedial action, on the other hand, is meant to bring the complainant as close as possible to where they would have been had it not been for the maladministration, improper conduct, and the prejudice. This is critical because this institution is one of the most cost-effective way of accessing justice. This is the spirit in which I wish all parties receive these findings. Lastly, I would thank the investigations staff of the institution led by the CEO and the acting CEO and the Chief Operations Officer for producing these reports. Thank you.
Thank you, Public Protector and Deputy Public Protector. We will now open the floor for questions and we will give the first bite to the colleagues who are in the room with us, the colleagues from the media who are in the room with us right now. There are others who are following these proceedings virtually, and they will be sending us questions via the WhatsApp group. So for now, let's see if we have any questions from the colleagues present here. Okay, let's start here. Mr. Mpiani will give you the microphone. Please introduce yourself and the institution you represent, and then you can pose your questions to the panel.
Good afternoon, Public Protector. With Mama from BNCA. I just want to find out, you had indicated that on the 3-day investigation that this is completed, but you're still awaiting some of those Section 79 responses. So is there any indication as to when that report will be finalized or will actually be issued to the public? And then secondly, it was noted earlier that with regards to the COVID-19 investigations, there were some difficulties. And in fact, the Public Protector's Office had indicated that it's even looking at possibly sending subpoenas to some of these officials that were actually not cooperating with the investigations. Is that still going to happen, or are the investigations now running smooth?
Thank you. Any more questions? Okay, let's say,
Good afternoon, Public Protector. My name is Bullet Chidi from ETV News. Just one question, just how confident are you this time around that seeking a jail sentence for Pravin Gordhan will prevail? Thank you.
Okay, any more questions? In the absence of any further questions, let's hand over to the Public Protector. And let's try to restrict the initial round of questions to the issues coming out of the statement.
Thank you, Program Director. ENCA, the 3-day investigation, the investigation is complete, though issuance of Section 79 notices are still part of the investigation, because Section 79 is very clear that during the investigation, where we pick up that there are implicated parties, we will issue them the Section 79 notice. So we regard it as part of the Audi Al-Garambarten rule, which is hearing the other side of in fact, hearing from the other side. So that has been done, and we've issued the Section 79s at the beginning of this month towards the second week. And unfortunately, yes, there was also a delay. Hence, we've indicated in the statement that we thought the matters were as simple and it will only involve those Free State politicians. But we had to then also request affidavits from all other politicians who were involved in this particular matter. We also had to engage and rely from the other law enforcement agencies because there's information which we would need from them. We'll also have to rely from other departments like the Department of Home Affairs, where there's allegations that there was traveling by some of the politicians to India. Therefore, the Department of Home Affairs, as the custodian of the movement control system, they are the ones who should be assisting us. So all those delays led to us having to send the Section 79 notice later than expected. And as I said, we give them 14 days to respond. That is in terms of the public protector rules. But unfortunately, then they also requested an extension. And hence I said, giving people an opportunity or as well making sure that there is that fairness. We don't want a situation where we issue a report and we are accused of not being fair, or as well we are taken on review because of that process which we have followed. And then regarding the difficulties we were facing relating to the COVID-19, I think the DPP in her address, she indicated that fortunately we then finally received cooperation, and there were some subpoenas which were issued to various parties. And in terms of the Public Protector Act, the Public Protector will determine how the investigation is conducted and how expeditiously that matter should be dealt with. So the provisions of the Public Protector are very clear on that. Hence, the issuance of the subpoena, we indicated that is not only because we don't receive cooperation, but also to finalize the matters speedily. So I must indicate that we got a report from the Chief Operations Officer that now the matters are moving smoothly, and we will be finalizing a lot of them, and especially those relating to conduct failure. And on the issue of ETV, I think as media, and as I said, you play a very important role in the work of the Public Protector and protecting the public, and also publishing or informing the public on factual issues. It would be very helpful that on a number of these issues, when they are raised in social media or in the newspapers, we are always available to clarify to the public. The spokesman is always available. There's nothing like that the Public Protector is asked for a jail term for Minister Pravin Gordhan. The affidavit of the Public Protector is reminding the executive or the minister that by alleging or accusing the Public Protector of being involved in corruption and state capture and fight back campaign, and also the derogatory manner in which some of the information is contained in his affidavit, that is an insult to the Public Protector. And Section 9 of the Public Protector is very clear that no one must insult the Public Protector. Therefore, expecting him, who has taken an oath of office in terms of Section 95 of the Constitution, to respect and be obedient to the Constitution. Hence, that was mentioned based on that. Therefore, I think it's a challenge that you will have headlines, which always we say, South Africans, can you read for yourself, and can you also get the information directly from us, so that we don't perpetuate this wrong narrative and as if the Public Protector is fighting with Minister Gordhan. But it's a question of making sure that Minister Gordhan respects the Constitution and also lead by example as one of the executive members. Thank you.
Thank you, Professor. Are there any more questions from the floor? In the absence of questions here, let me check on the WhatsApp line. We have SABC in Cape Town. They want to hear from the public projector about progress insofar as the case involving her challenge of the rules upon which Parliament is embarking on the approval process. That's the first one. And then secondly, they would like the public protector to comment briefly on the Supreme Court of Appeal judgment on the James matter, which was handed down yesterday. Thank you.
Thank you, Mr. Sekhalwe. The SABC, we haven't heard from Cape Town on the outcome of the interdict. Remember, we were interdicting the continuation of the process until such time Part B is heard. We are awaiting the outcome. And I must indicate that throughout the process, we've been engaging the speaker and others that at least let them stop with the process so that we can hear the outcome of the Part B. We are awaiting the judgment in that, and I think it's public knowledge that the judgment was reserved. And the second one, the SCA judgment on the issue of GEMS. We're still studying that particular judgment. And I think the question SABC should be asking, and maybe you should be also locating Mr. Mwatu, because we were acting on behalf of Mr. Mwatu, and that's the person who's being prejudiced in this particular matter, and any other member of GEMS. So I think we will pronounce on that as soon as we go through the judgment and decide whether we are fine, we can just let it go, or then comment on how we will be taking the process forward. Thanks.
Thank you, Public Protector. There are no further questions on the WhatsApp line. I don't know if anyone still wants to say something here. In the absence of questions here, the press conference is adjourned. Thank you very much.
Yeah, but